Imagine this. You are a lawyer. You rush to a police station because your client has been arrested. You walk in with confidence, with your briefcase, with your bar card. And then a police officer stops you at the door and says, "You cannot go inside. No one is allowed." What do you do in that moment? Do you step back? Do you argue? Do you know your rights? Most advocates don't. And that silence, that moment of not knowing, is exactly what this video is going to fix. Today, we're going to talk about the rights of an advocate inside a police station, slowly, clearly, with real-world examples, because knowing your rights is not enough. You must know how to use them, calmly, firmly, and with full legal authority. Before we dive into the law, let us first understand why this matters. In any justice system, the lawyer is the bridge between the accused and the court. Without that bridge, justice cannot reach the person who needs it most. But that bridge can be blocked, sometimes by ignorance, sometimes by ego, and sometimes by the misuse of power inside a police station. Every single day in cities and towns across Pakistan, India, and many other countries, lawyers face resistance when they go to police stations to meet their clients. They are told to wait. They are told visiting hours are over. They are told the accused is being interrogated and cannot be disturbed. These excuses sound official. They sound reasonable, but many of them are illegal. So let us go through your rights one by one, step by step, with real-world examples so you never feel lost again. The very first and most fundamental right of an advocate at a police station is the right to meet the accused. Let us be very clear about this. Once a person is arrested, they have the right to consult a lawyer. This is not a privilege. This is a constitutional right. In Pakistan, under Article 10 of the Constitution, every arrested person must be informed of the grounds of their arrest and must be allowed to consult a lawyer of their choice. In India, the same protection exists under Article 22 of the Constitution. The moment an accused is in custody, the clock starts. They have a right to legal counsel, and you, as their advocate, have the right to see them. Now, here's a real example. Suppose your client, let's call him Ahmed, is arrested at 9 p.m. on a Tuesday. The police take him to the station. You arrive at 10 p.m. The duty officer says, "We're busy. Come back tomorrow morning." This is wrong. You have the right to insist on meeting your client, not aggressively, not by shouting, but firmly and legally. You can say calmly and clearly, "Officer, under the Constitution, my client has the right to consult his lawyer. I am his legal counsel, and I am here to meet him. Please allow me to do so, and please note the time and my request in the station diary." That one sentence changes everything. You have created a record. You have invoked the law, and you have done it with professionalism. Here's the key thing to understand. The police cannot deny you access to your client without a legal reason. If they do, that denial itself becomes evidence of a rights violation, which you can take to a judge, which means the police also know this. So when you speak the language of the law, calmly and correctly, most officers will step aside. The second right, and this one surprises many advocates, is the right to be present during interrogation. In many legal systems, once a person is formally arrested and in custody, their lawyer has the right to be notified before any interrogation begins. The police cannot begin questioning your client in secret while you are sitting outside in the waiting area. Let me give you another example to make this concrete. Suppose your client, Bilal, has been brought in for questioning regarding a fraud case. The investigation officer calls Bilal into a room and begins asking questions. You are outside. You do not know this is happening. Later, Bilal signs a statement, perhaps without fully understanding what he signed. That statement may be used against him in court. Now, if you had been present, if you had been notified, if you had been allowed inside, you would have advised Bilal on what to say and what not to say. You would have ensured that the statement was accurate, voluntary, and not coerced. This is exactly why the right to be present during interrogation exists. It is not to obstruct justice, it is to protect it. In practice, you should always announce your presence at the station clearly. Go to the duty officer, state your name, state you are the legal counsel for the accused, and ask to be notified before any questioning begins. This simple step puts the police on notice and protects your client. Now, let us talk about something that very few advocates know to use, the station diary, also known as the Roznamcha or daily diary. Every police station is required by law to maintain a daily record of all arrests, arrivals, departures, and significant events. This diary is a legal document, and as an advocate, you have the right to inspect relevant entries in that diary. Why does this matter? Because the station diary tells you the truth. It tells you exactly when your client was arrested, what time they arrived at the station, whether they were produced before a magistrate on time, and whether the legal timelines were respected. For example, under Pakistani law, under Section 61 of the Code of Criminal Procedure, a person cannot be held in police custody for more than 24 hours without being produced before a magistrate. If your station diary shows that your client was arrested at 6 a.m. on Monday, but was not produced before a magistrate until Wednesday morning, that's a clear violation, and now you have evidence, written, official, in the police's own handwriting. How do you ask for this? Again, calmly. You go to the station house officer, the SHO, and you say, "I am the counsel for the accused. I would like to review the relevant entry in the station diary regarding my client's arrest and custody." You do not need to fight. You do not need to threaten. The law gives you this right. Use it quietly and use it firmly. The fourth right is one that seems obvious, but is often violated in practice: the right to know exactly what charges your client is facing. When you arrive at a police station, you are entitled to know under which section or sections of the law your client has been arrested. The police must inform you of the FIR number, the relevant sections, and the nature of the alleged crime. Without this information, you cannot give proper legal advice. You cannot make bail applications. You cannot prepare a defense. And yet, it happens regularly. Advocates arrive at police stations and are given vague answers like, "It is a serious matter," or "The investigation is ongoing." These answers are not good enough. Here is what you should do. When you arrive at the station, ask clearly, "What is the FIR number? Under which sections of the law has my client been booked? Has the FIR been registered yet, or is this a pre-FIR detention?" These are your legal rights to know. If the police refuse to tell you, you should note the time, the officer's name or badge number if visible, and the refusal itself. This refusal can later be presented before a magistrate or a high court in a habeas corpus petition. Now we come to the most practically important section of this video. What do you do when the police are hostile? What do you do when an officer raises his voice, when he tells you to leave, when he threatens you with obstruction of justice charges? This is where your composure is your greatest weapon. Here is a truth that every experienced advocate knows. When a police officer becomes aggressive toward a lawyer who is simply trying to meet their client, it is almost always because that officer knows they are doing something wrong. Aggression is not strength. Aggression is fear wearing a uniform. So do not match that aggression. Do not shout back. Do not threaten. Because the moment you lose your temper, you lose the moral and legal high ground. What you should do instead is this. First, remain calm. Take a breath. Lower your voice, not raise it. Second, state your identity and your purpose clearly and formally. I am advocate, your name, enrolled with the Bar Counsel name. I am here as legal counsel for client's name, who is currently in custody at this station. I am formally requesting access to my client in accordance with my constitutional and statutory rights. Third, if you are still denied, ask for the name or badge number of the officer who is refusing you. The moment you ask for identification, the dynamic often shifts. Fourth, inform them that you will be reporting this denial to the relevant bar association, the district and sessions judge, or the high court, not as a threat, as a fact, because that is exactly what you should do. Finally, leave the station peacefully. Do not create a scene. Go directly to a magistrate or the duty judge and file a complaint. The courts take violations of legal access very seriously. Here is something very important that many advocates do not think about until it is too late. Can the police arrest you, the advocate, inside the police station? In theory, yes, if you have committed a cognizable offense, but in practice, any attempt to arrest an advocate who is simply doing their job, meeting a client, asking legal questions, inspecting records, is itself an illegal act. The law protects advocates from harassment and intimidation while they are performing their professional duties. If a police officer tries to detain you, threatens to arrest you, or physically obstructs you while you are performing your lawful professional duties, this is a serious matter. It can constitute criminal intimidation, wrongful confinement, and misconduct under the police order. You should immediately contact your bar association. You should call another advocate to come as a witness, and you should document everything: the time, the place, the officer's words, the exact sequence of events. Let us now bring everything together into a practical checklist. Every time you go to a police station, do these things. 1. Carry your bar enrollment card and a copy of any vakalatnama or written authority from your client. 2. Note the time you arrived and keep a record on your phone or in a notebook. 3. Announce yourself formally to the duty officer and state your purpose in clear legal language. 4. Ask for the FIR number, the sections charged, and the full name of the accused on record. 5. Request access to your client and ask to be notified before any interrogation. 6. If denied access, ask the officer's name, note the refusal, and leave peacefully. 7. Immediately go to a magistrate, the sessions court, or if necessary, the high court, and file an appropriate application. 8. Report the incident to your bar association so that a formal record exists. 9. Always remain professional, composed, and lawful in everything you do, because the system watches both sides, and a composed, informed advocate is far more powerful than an angry one. I want to end this video with something that goes beyond law, because knowing your rights is only half the battle. The other half is believing you deserve to use them. Every time an advocate walks into a police station with knowledge, with calm, with professionalism, they are doing something deeply important. They are reminding the system that the law applies to everyone, not just to the accused, not just to the victim, but also to the officers who carry a badge and to the lawyers who carry a briefcase. The rule of law doesn't enforce itself. It needs people, like you, to stand up for it, quietly, firmly, every single day. You became an advocate not just to argue in courts. You became an advocate because you believed that every human being deserves to be treated with dignity and fairness, even the ones locked in a cell, even the ones whose names are in an FIR, even the ones the world has already judged. When you walk into a police station and say, calmly and clearly, "I am here for my client and this is my right," you are not just doing a job. You are being the last line between power and a person who has no one else. Never forget that. Never let anyone make you feel small for doing it. And never, ever walk into a police station without knowing exactly what rights you hold in your hands. If this video helped you, please share it with every advocate you know. Leave a comment below about any experience you have had at a police station, and subscribe because we make content like this every week, slowly, clearly, and deeply for advocates who want to know the law inside and out. Thank you for watching. May your words always carry the weight of justice.